Number 8, this is an issue that popped up because this guy came to me and analyzed his case. He had several lawyers that messed up and didn't understand it. If you're, and this is the marriage green card course, this is what it's all about. Why it's like the best course out there, because we read the statute and learn the law, not just reading cover letters. But under Immigration Nationality Act, Section 245, that's adjustment based primarily. This is asylum based adjustment, which is separate, but this is the main adjustment statute, INA 245. There's a section called C, and then within that there's C8. And essentially, this is a scenario. If someone has ever had an immigration violation and they file for a green card, they can't get a green card. They have to do consular processing. There are exceptions to that. For example, married to U.S. citizens or something like that. But the reality is this. Sometimes people have a violation. They leave the U.S. They come back in. They think that cleans it up. But it doesn't for certain cases. So it doesn't matter. It cleans it up for marriage adjustment, for example. Even the violation before could have fixed it up. But if you have an employment-based case and the person is able to come back in for that case with admission, not parole, 245K kicks in. So previous violations get erased or not. I mean, it's not what the violation is, but essentially they're not problematic for adjustment. You can still do that. However, it doesn't work, for example, if you're married to a green card holder. So let's say a person overstays an F1 visa, goes back out and comes back in with parole or TPS at readmission or something like that. They already had lawful entry, so that was an issue. The issue was that they did not keep continuous residence, so they had violations by not doing that. So they're not able to adjust if they marry a green card holder. Now, USCIS may still approve the case mistakenly. That happens, but it doesn't mean it's correct. So C8 is very important to be aware of. Previous violations, even 20 years ago, will prevent a person from adjusting unless they fall within the exceptions of a marriage to U.S. citizen, potentially employment-based kind of case, 245K, 245I, that kind of stuff. But others don't. Marriage to a green card holder is always something you have to be sensitive about because the protections that you get of being married to a citizen are always there. Sometimes it's best to have the U.S. spouse become a citizen before filing because there's all sorts of protections.